Let me go ahead. I'll go over to page 4 then and call Christopher Wren versus Affinity. And let's take appearances starting first with the plaintiff.
Good morning, Your Honor. Eric Pepperman on behalf of plaintiffs.
Are there other plaintiffs? And then for the defendants, please.
Morning, Your Honor. Karen Bashor on behalf of Nevada Beverage. Here on the right on behalf of the carrier plaintiffs and for these matters.
Thank you. Other appearances on the phone? Because we had 2 joinders.
Good morning, Your Honor. Xheni Ristani for Xheni Lifestyles and Real Water.
Thank you.
Good morning, Laureen Frister on behalf of Xheni Distributors of Nevada.
May I have your name again, please?
Laureen Frister, bar number 13217.
Thank you.
And Your Honor, James Neale on behalf of defendant UNFI in a coordinated matter, joining in the objection and admitted pro hoc PJ.
Good morning, Your Honor. Colt Dodrill, bar number 9000, co-counsel for Nevada Beverage.
Good morning, Your Honor.
Good morning, Your Honor. Sorry. Good morning, Your Honor. Jacquelyn Franco, bar number 13484, on behalf of Sprouts in the coordinated matters.
Thank you.
Good morning, Your Honor. Jason Fowler, bar number 8071, on behalf of Walgreens in one coordinated matter.
Is that
Good morning, Your Honor. Alexander Adrian, bar number 15695, on behalf of Costco. I believe in one of the coordinated matters, my files aren't working right now.
Good morning, Your Honor. Elizabeth Lowell on behalf of Milwaukee Instruments, bar number 8551.
Good morning, Your Honor. David Spurlock on behalf of UNFI, bar number 2565.
Is that everyone? Okay. All right. So there was an objection by Nevada Beverage to the special masters to an order. And Ms. Bashor?
Yes, Your Honor. Thank you very much. Good morning, Your Honor. Nevada Beverage, I'm not going to regurgitate the briefs, Your Honor. I know that you've read everything. You're very well prepared. But there are a couple highlights I do want to hit. Nevada Beverage asked this court respectfully that you sustain our objection, that you overrule the special master's order, and that you narrowly tailor it to relevant information subject to a stipulated protective order that we believe is appropriate in this case, and that the parties are near agreement on. And we believe also, Your Honor, that you should deny the counter motion with respect to fees and costs. We believe that is not warranted at all, Your Honor. And the things that I do want to hit is the context. It is unfortunate that we are before you, and we are sorry that we had to request court intervention with respect to this situation. But what's unfortunate about this situation is that we don't believe that we had a full opportunity to address the substance of the subject of the order. The order that was issued by the Special Master Hale, and while I'm sure there was no ill intent behind it, it was based upon a complex. It was based upon a bad situation, Your Honor. We did not have an adequate opportunity to make a full record below. To the extent there's any arguments with respect to any waiver of arguments, we did not have that opportunity, Your Honor. A request was made of Nevada Beverage. It was made informally, without any formal discovery. It was made in a context where there was no case management order or discovery plan in place. The plaintiffs at that time had not issued any 16.1s with their medical records or computation of damages. It was very early on in the case, upon the remand order being issued, and as Your Honor has seen from the federal court order, there was no indication of any frivolousness or gamesmanship or any improper delay tactics indicated in that order. And when coming back from that remand order, and everybody was trying to get together with the special master and try to coordinate discovery, this informal request was extended. We indicated that we were not comfortable without formal discovery to address that issue, and that issue was placed on the agenda for the special master hearing with less than 2 hours for us to have any notice of. I was not present at the hearing. I had no idea that this was going to be, turned into this situation. My counsel was present, and he addressed the issue as best he could under that situation. There was no request for sanctions or fees or anything like that for any failure to turn over that discovery that's been indicated. And what's at issue here, Your Honor, is a very broad request for the entire list of retailers for which Nevada Beverage distributed real water to for a number of years. Completely broad request, not narrowly tailored. Most of the retailers on that list are not involved in any way in this litigation at all. And to this date, they have not been named by plaintiffs at all in their 16.1 disclosures. The information that is being requested is fully in the hands of the plaintiffs, Your Honor. The information that's being requested is not relevant because they're not parties to this litigation. They're requesting for information with respect to non-parties. And while these attorneys are working with the special master to try and coordinate discovery, that does not mean that the rules go out the window. That does not mean that there are procedural shortcuts. That does not mean you circumvent the rules and the proper policies and procedures that are in place. What should occur if legitimately what they're after is potential parties that should be added to the litigation, what should occur is that the plaintiffs, with information as to where they obtained their real water from, should indicate in their complaint the retailers where they bought real water, which they believe caused their damages and caused them to be ill. That should be indicated in the complaint. That information should also be indicated in the 16.1 disclosures, which they are not. Then there should be proper formal written discovery to obtain additional information with respect to those retailers and any other additional distributors that are necessary. In a case management order, there is a deadline set in place for a deadline to amend the pleadings to add additional parties, which is to encourage all parties to try and obtain that discovery through legitimate, proper means under the rules, under proper channels, and those parties can then be added to the litigation, Your Honor. What's being asked at this time in this context is overbroad, is requesting for irrelevant information that is not proportional to the needs of the case. Counsel has not made the argument for the relevance of this information. The only argument that I've been able to discern through from what's been indicated at the special master hearing, from the order, and from the briefing that has been indicated, and there was no joinder by other plaintiffs with respect to the opposition to the motion or the counter motion for fees and costs. The only argument I can discern is efficiency. And we've all dealt with this issue before. There is a very distinct difference between efficiency and proper joinder. Efficiency is not a scapegoat for the rules, for the policies, for the case law. Efficiency does not replace relevance, and that is not the threshold here. To the extent that there is any argument that there's no harm to us, that this doesn't prejudice Nevada Beverage because this information was purportedly on the website at some point in time. The information that's being requested, my understanding, was not completely on the website at a prior point in time, and the circumstances have drastically changed. There is now litigation that's involved. While we are not we're not arguing trade secret. This is important business information. We have business relationships with these numerous other retailers that are on that list who are not parties to the litigation. There is information and videotape depositions that have already been leaked in this case that have caused a lot of issues. So to the extent that there is any argument for any of this information, which purports to be a potential fishing expedition, Your Honor, we have a legitimate concern as to the relevance of this information, protecting that information, and making sure that it is narrowly tailored and subject to a protective order. We believe that the counter motion for fees and costs is completely unwarranted. While counsel may want to downplay this issue, it's a serious issue. It has great magnitude, it has great consequences, and we take it very seriously. And I and other counsel who may have meritorious objections should not be stifled from bringing those objections to the court's attention under the proper rules, channels, and procedures. Again, we don't believe that this order was brought out properly. We don't believe that counsel can deny our request procedurally and substantively. We believe it's a very reasonable request, Your Honor, and on that I will submit to our papers and we ask that you grant our motion.
Before I hear the opposition, I'd like to hear the jointers. Let's have first AffinityLifestyles.com, DBA Real Water.
Good morning, Your Honor. Xheni Ristani for Affinity Lifestyles and Real Water. Yes, we just joined the arguments regarding the fees and costs and sanctions. Under NRCP 53F, the parties may object to the special master's report and recommendations, and they may seek court review of the special master's orders. They should not be concerned in this instance and moving forward that every time they seek review of the order that they're going to be facing sanctions. There's no basis for sanctions here or for fees and costs. So on that, we join the motions of Nevada Beverage, and I'll submit on the papers.
And United Natural Foods, Inc.
Thank you, Your Honor. Jim Neale on behalf of UNFI. I would just point out that the defendant, Nevada Beverage here, is facing a motion for sanctions for objecting to a special master ruling compelling the production of a distributor list that it never received a request for production for. We join the motion for that reason, Your Honor.
Anyone else have a joinder before I hear the opposition?
Yes, Your Honor. Kihei Distributors of Nevada filed a joinder to Nevada Beverage's objection. And I don't have any additional argument to make.
Thank you. Any other comments? The response, please.
Thank you, Your Honor. I have to confess that I'm fairly flabbergasted that we're here over this. Let me try to just explain what it is we're looking for and why. So if you go to Nevada Beverage's website, you can see every single brand that they distribute in Las Vegas. Budweiser, Fiji Water, any number of products. You can click on that brand and you can open up every single retail location where Nevada Beverage distributes that brand. And it was the same for Real Water. And so about 3 months ago, after we were held up on remand on a removal for 8 months, as we were about to be remanded, waiting the order, I contacted Mr. Dodrill, Nevada Beverages counsel, and said, hey, would you be willing to produce your distribution list, what was previously published on the website, informally, without, while we're waiting to get the remand finalized. And the reason I did that was because we're in the process of amending our complaints. There's close to 10 of them. And we did not know the distributors for many of the retailers that we named in those complaints. So, for example, in one of our cases, Wardson, we sued the retailer where our client bought the Real Water. It was a Terrible Herbs store. But we did not sue Nevada Beverage because we did not know that Nevada Beverage distributed Real Water to that Terrible Herbs location. So Terrible Herbs filed a third-party complaint against Nevada Beverage to bring them in, and now we have to amend our complaint to assert a direct claim against Nevada Beverage because we know that Nevada Beverage was the distributor there now. In another complaint, the Henry complaint, we sued several retail stores that at the time we did not know that Nevada Beverage was the distributor for, that we still don't know with certainty because we don't have the list, but we believe Nevada Beverage was the distributor. So we would like the distribution list to confirm whether we need to add Nevada Beverage to that complaint while we're going through the process of amending it. And there are several other cases where we're not sure if Nevada Beverage distributed, or we want certainty, or we want to confirm that they didn't distribute to those defendants, so we could pursue the store, the distributor who did distribute the Real Water to those stores. So it's really information that is not trade secret, it's not privileged, it's published on the website, it's in their possession solely because it's not on the website anymore, and it's for the relevant purpose of avoiding serial amendments down the road as we figure out where these stores received the real water from and identifying other parties. And so for that purpose and other purposes in discovery, I asked Mr. Dodrill if his client would be willing to just informally produce the list so we could clean up these complaints, make sure we have all the proper parties in now as we get remanded and as we get back going in the state court. And he responded and said, no, we want to wait for a formal discovery request. And I said, well, I don't think that's necessary, but I'm going to bring it up at the next special master hearing, which was a few days away. I'm not sure. It was more than 2 hours notice. And it was on our proposed special master agenda. At the next special master hearing, as I told Mr. Dodrill I would, days earlier, I raised it with Special Master Hale and said, look, we're trying to identify all the proper parties, clean up our complaints, make sure that we have any unnamed parties that we're adding, make sure that we're suing Nevada Beverage in the cases where they're the distributor into the stores where our clients allege they bought real water. And we would like to get that now because we're in this process without waiting a formal discovery request and 30 days and objections and responses. We would like to just address this now. Special Master Hale heard the arguments. It was, we don't think we should produce the whole list. We should wait for formal discovery, the same things that we heard. And Special Master Hale said, well, we don't need a formal discovery request because this is information that should have been disclosed as a mandatory 16.1 disclosure. No question about the relevance of this list. It's routine discovery in a products liability case where we're looking for the distributors. Just the fact that the list includes non-parties or non-defendants is equally relevant because those are avenues for potential third-party discovery that we're going to look at. It's not harmful to these stores. They sold real water. If they're not named in the lawsuit, then they didn't sell real water that made people sick. And if they did, they're going to be identified and sued for that on that basis anyways. And it was published on the website. So it's routine, highly relevant, and so much so that Special Master Hale said, well, that's a mandatory 16.1 disclosure. Those have already been ordered to be produced. You should have produced it then, so I'm going to order that you produce it now. And that was it. There was no motion or request for briefing or anything. Special Master Hale even gave 4 additional weeks, which I thought was a long time. And what we got was the total amount of days that you could wait and then filed an objection. And now here we are, about almost 3 months later, close to 50 pages of briefing and joinders and out-of-state counsel and hearings and arguments over something so simple that it just boils down to the most basic question: is this court going to reverse Special Master Hale's order that this is a 16.1 mandatory disclosure and preclude this plainly relevant, routine, non-privileged, non-confidential information that was routinely published on Nevada Beverage's website? It's confusing to me why we're here wasting all this time and money arguing over something like this. And that is the genesis of the request for fees and costs. Your Honor, I don't want to belabor this point. I don't take delight in asking for fees and costs, and to be frank, I'm not looking for fees and costs. The minimal amount of money that we would get is not what is important here. What is important is I have a concern about the special master process being abused. And maybe we have not gotten to that point yet, but I think it's important that very early on we establish that if you're going to make objections to the special master order, there has to be a reasonable basis and a good faith basis for it. And that has to be a question that's looked at. Because if we adopt this circular argument by the pure fact that they objected to the special master order is automatic assumption that it was in good faith because they did it, then there's a potential for it to get out of hand and be abused for delay and time-wasting purposes. Because if you look at this, something so simple, which is holding up our ability to amend our complaints accurately, it's holding up our ability to get the proper parties in at this stage. That's why Special Master Hale ordered this discovery to be produced more than a month ago. And here we are 3 months later where we don't have the information. We've spent a ton of time fighting over it. And if every little thing that they don't agree with from Special Master Hale is objected to and takes up this much time, I just am concerned that that could lead to an incentive to abuse the process. And if nothing else, I just want to make the record that we are looking at that and concerned about it. So with that, I'd ask Your Honor to leave Special Master Hale's order in place, and I'll defer to Your Honor if you think fees and costs are warranted in this situation.
Thank you. In the reply, please.
Yes, Your Honor. I'll be brief, and I do want to allow my co-counsel to address any issues that he believes need to be addressed on the record based upon counsel's remarks. But I just do want to indicate for the record that counsel talks about it being so simple. It is simple. It is simply irrelevant. If the plaintiffs complain, by analogy, that they only got sick at McDonald's, then it is completely irrelevant whether we distribute it to Burger King or Wendy's. That's how simple this is. It's not relevant. Non-parties are not relevant, and a request, overbroad request, not subject to a protective order, narrowly tailored to what's really at issue in this case, is not proper, and that order was not proper. And we're asking Your Honor for your relief. I would like my counsel to address any issues he believes necessary.
And would that be Mr. Dodrill?
Mr. Dodrill, yes.
Mr. Dodrill, if you have anything further?
Thank you, Your Honor. Colt Dodrill, bar number 9000. I don't have much to add. Obviously, I agree it's not relevant, and that takes it outside the scope of 16.1. Rule 26 allows the court to limit discovery. I don't see any rule that allows the court to expand discovery, and the court should limit what we need to produce to what is relevant, which is those retail locations alleged by plaintiffs or included in their 16.1 as to where they purchased the product. Anything else is a fishing expedition that's improper.
Matter submitted. This is the objection of Nevada Beverage to an order entered by the special master. I'm going to overrule the objection, but the request for sanctions will be denied by the plaintiff. The complaint goes back to March 16 of 2021. I think that the special master, his interpretation of Rule 16.1 was appropriate. This is information that could have been done as an initial disclosure. The law does require me to give some deference to hearing officers in general. I don't find his decision was arbitrary or capricious. In fact, the decision I thought was done to promote efficiency. So for those reasons, the objection will be overruled. Mr. Pepperman will prepare the order from today's hearing. Ms. Bashor, I assume you would like to review and approve the form of the simple order?
Yes, Your Honor.
If there's anyone else who wants to approve the form of a simple order, give us your name and bar number, please. Have no takers? All right. Then thanks everyone for your appearance today. Stay safe and healthy.
Your Honor, I'm sorry, if I could address one issue is the production of the list. I don't know if there's an amount of time that Nevada Beverage would need to comply with the special master's order, but I just don't want to leave that open-ended if we can kind of close it.
Let me say within a reasonable time after entry of the order, and if you have problems with enforcement of the order, go to the special master first.
Thank you, Your Honor.
Okay,
And Your Honor, I'm sorry, for purposes of clarification, will that production be subject to the stipulated protective order?
I thought you argued that there was not one yet in place.
Yes, I believe the parties, it was circulated and it's almost agreed upon. I believe it's almost agreed upon, so there should be one in place in the
I'm
near
not-
future.
I'm not conditioning this relief upon entry of an SPO. Okay, thank you. Any other questions?
No, Your Honor, thank you.
All right, let's go to page 15.